My father taught me one lesson about this work that has never left me. Not in 22 years on this bench, not through the hardest cases and the longest days, and the moments when the weight of the decisions in this chair felt almost too heavy to carry. He said the prosecutor's job is to seek justice, not to seek office. When they forget that difference, judges must remind them that justice serves the people, not the politicians. I thought about those words on a Tuesday morning when District Attorney Michael Brennan walked into my chambers without knocking, without an appointment, without so much as a pause at the door to consider whether what he was about to do was something a man in his position should ever do, and told me he needed me to dismiss a case, not because the evidence was weak, not because the law required it, because it was inconvenient for his political future. I want you to understand what that moment felt like, because it is easy to read those words and think of them as a courtroom drama, as something abstract and distant. It did not feel abstract. It felt like watching an institution I had devoted my life to being used as a personal tool by a man who had long since confused his oath with his ambitions. By the end of that week, the only thing dismissed was his career. But let me start from the beginning, because the beginning matters, and because the person at the center of this story deserves to be seen clearly before we talk about the men who tried to make her disappear. Her name was Sarah Martinez, 22 years old, a college student working part-time at Providence City Hall to pay her tuition when Councilman Robert Sterling, a man with political connections that stretched across every level of city government, a man who had brought millions in development money into Providence and wore that fact like armor, cornered her in his office after hours on a Friday night when the building was supposed to be empty except for cleaning staff. What Sarah had when she came forward was not a he said, she said situation. It was not ambiguous or complicated or subject to reasonable interpretation. She had security camera footage from City Hall showing Sterling following her into his office at 8:47 p.m. She had photographs taken by emergency room staff at Rhode Island Hospital documenting physical evidence that matched her account in precise detail. She had text messages from Sterling's personal phone sent the following morning threatening her job if she caused unnecessary trouble over what he called a simple misunderstanding. She had witness testimony from other women Sterling had harassed. The evidence was overwhelming. Any honest prosecutor reviewing that file would have filed charges without hesitation. Michael Brennan reviewed that file and spent 6 months doing nothing, hoping the case would quietly fade from public attention before it could damage the man who was his biggest campaign contributor, his most powerful political ally, and his most direct pathway to higher office. I first learned the full scope of what was happening when Sarah's attorney, Patricia Chen, came to my chambers. She had just left a meeting at the DA's office, and she looked like someone who had walked into a building expecting solid ground and found it missing entirely. She sat across from my desk and told me that DA Brennan had informed her he was dropping all charges against Sterling, not because the evidence was weak, but because it was too strong. He had told her that prosecuting Sterling would destabilize municipal government and harm community relations. He had been pressuring Sarah directly to withdraw her complaint, suggesting that going through with the case would only hurt everyone involved. When Sarah refused, and Sarah Martinez refused, every single time with a clarity and a courage that I had thought about many times since Brennan had tried to bribe her. City jobs, scholarships, anything that might make the case disappear and preserve the political relationship that mattered to him more than the legal obligation that was supposed to define his office. Attorney Chen told me that Brennan had said in a meeting she would later testify to under oath, sometimes justice has to take a backseat to political reality. I sat with that sentence for a long time after she left my chambers. Justice taking a backseat to political reality. That is not a gray area. That is not a difficult prosecutorial judgment call requiring professional discretion. That is a prosecutor telling a victim's attorney that her client's assault matters less than his election prospects, and believing, with the complete confidence of a man who has operated without real accountability for too long, that this is an acceptable thing to say out loud. What I learned in the weeks that followed through court records and a confidential meeting with FBI Special Agent Maria Santos was that Brennan's corruption was not a single instance of bad judgment. It was a system. Agent Santos had been investigating him for 8 months, and what her team had assembled was a documented pattern of prosecutorial misconduct that went back years and touched case after case after case. 17 dismissed cases involving politically connected defendants over 3 years. Sexual assault, domestic violence, anything that might embarrass a donor or cost a campaign contribution, quietly buried. A restaurant owner who had beaten his wife so severely she required facial reconstruction surgery, case dismissed because he had donated $50,000 to Brennan's campaign. The city contractor who had embezzled $2 million in public funds, charges reduced to a misdemeanor fine because he had promised to finance Brennan's run for attorney general. And the pattern with sexual assault cases was the most sickening of all. Any perpetrator with political connections or financial resources found reasons appearing from the DA's office to dismiss charges or offer plea arrangements that involved no jail time whatsoever. While defendants without money or connections were prosecuted with the full force of the office, Brennan had built what Agent Santos described to me as a protection racket, a system in which powerful men could commit crimes without fear of prosecution as long as they supported his political career. She played recordings the FBI had obtained through wiretaps. His voice was unmistakable, calm, and strategic, explaining his philosophy. We have to be strategic about which cases we pursue. He said, going after community leaders destroys relationships that take years to build. Sometimes the greater good requires protecting people who serve the public interest. The greater good. Protecting sexual predators was the greater good to a man who measured justice in campaign donations and calculated every decision by what it meant for the next election. Then came that Tuesday morning. Brennan walked into my chambers without knocking, sat down without being invited to sit, and told me in the smooth political tone of a man accustomed to managing difficult conversations that he was planning to dismiss all charges against Sterling due to insufficient evidence. I told him the evidence was quite strong: security footage, physical evidence, witness testimony. He told me I didn't understand the complexity. He told me Sterling was a community leader whose prosecution could destabilize municipal government. He told me that one woman's accusation shouldn't destroy years of public service, calling what Sarah Martinez had endured and documented and fought to bring forward one woman's accusations, as if the photographs and the footage and the text messages and the witness testimony were somehow just a matter of perspective. I told him it was not his job to protect city councilmen from the consequences of their actions. He told me it was his job to consider what was best for the community as a whole, not just individual complainants who may have misunderstood situation. And then he leaned forward in his chair in my chambers with the manner of a man inviting a colleague into a confidence, and said that Sterling had been very supportive of judicial campaigns in this city, and that Sterling understood the importance of electing judges who understood community needs. He was suggesting directly, without even the pretense of subtlety, that a sexual predator's political donations should influence my ruling. I kept my voice level, I kept my face still, and I let him keep talking, because what Brennan did not know was that I had been recording our conversation from the moment he walked through my door without knocking. Because when prosecutors arrive unannounced in judges' chambers to discuss pending cases, the integrity of the judicial system requires documentation. And I had learned that lesson long before Michael Brennan ever sat across from my desk. He kept talking. He told me he was ordering me. Those were his exact words. I am ordering you to dismiss the case immediately, citing prosecutorial discretion, insisting the case ended today. I am ordering you, a district attorney in a judge's chambers, ordering the judge to dismiss a sexual assault case to protect his campaign contributor. And then when I did not immediately comply, when I instead asked what would happen if I refused, Brennan's mask came off entirely, and what was underneath was exactly what I had suspected from the moment he walked in without knocking. He told me that district attorneys have long memories. He told me that judges who don't support prosecutorial discretion often find themselves facing well-funded opponents in election years. He was threatening me with electoral destruction to cover up a sexual assault. He was sitting in my chambers and threatening me. I asked him directly, "Are you threatening me?" He told me he was explaining political realities that judges sometimes forget. He told me I served at the pleasure of voters who trust elected prosecutors. I told him I served justice, not his political ambitions. He actually laughed, and said that justice is whatever keeps the community stable and prosperous, and that one girl's regrets about a consensual encounter weren't worth destroying Sterling's contributions to the city. Consensual encounter, that was the phrase he used for what the security footage and the hospital photographs and the threatening text messages documented. Consensual encounter. I let him finish. Then I called FBI agent Maria Santos. When Agent Santos heard the recording the following morning, her response was immediate. She told me that what I had captured was clear evidence of obstruction of justice, abuse of office, and conspiracy to deny civil rights, and that it was the final piece of a federal investigation that had been building for 8 months. On Friday morning, FBI agents arrested DA Michael Brennan at his office. The news moved through the city's political establishment like a current, and for me, sitting at my bench that Friday afternoon, it felt like something that had been wrong for a very long time was finally, slowly beginning to be made right. But the real moment, the moment I will carry with me, came the following Monday morning when Brennan appeared in my courtroom, no longer as a prosecutor, but as a defendant. The man who had walked into my chambers 5 days earlier and told me he was ordering me to act, who had threatened my career and called a sexual assault a consensual encounter, and laughed at the word justice. That man sat in the defendant's chair, looking like someone who had finally, for the first time, understood what it meant to be subject to the same system he had spent years corrupting. His attorney argued that Brennan had served the community faithfully for 12 years, prosecuting thousands of cases. I played the recording. His own voice filled the courtroom. "I am ordering you to dismiss this case immediately." The gallery erupted. When the room settled, I looked at him and said what needed to be said. In America, prosecutors do not give orders to judges, and justice serves victims, not political ambition. Even then, even sitting in the defendant's chair with federal charges against him and his own words playing back in a packed courtroom, Brennan told me he had been trying to protect the community from unnecessary division and trauma. He still did not understand, or perhaps he understood perfectly well and simply could not stop performing the only version of himself he had ever built. I sentenced him to 8 years in federal prison for obstruction of justice, conspiracy, and civil rights violations. I ordered a complete review of every case he had dismissed over 12 years as district attorney. I permanently barred him from public office, revoked his law license, and ordered full restitution to every victim whose case he had buried for political gain. He collapsed in his chair as the federal marshals prepared to take him. As they let him out, he turned back and said I didn't understand what I had done to the community's stability. I told him I had restored it. What followed in the months and years after that morning was the closest thing to genuine institutional repair that I have seen in my time on this bench. The new district attorney, Patricia Santos, immediately reopened dozens of buried cases. Sterling went to trial 4 months later with a prosecutor who actually wanted to win, and the jury heard evidence that he had sexually assaulted 5 other women over 8 years. All cases Brennan had dismissed or reduced, with bank records showing Sterling had made substantial donations to Brennan's campaign fund within days of each allegation becoming public. Sterling was convicted on all charges and sentenced to 8 years in state prison. During her victim impact statement, Sarah Martinez stood in that courtroom and said something I will never forget. She said, "When DA Brennan tried to silence me and protect my attacker, I thought powerful men could do whatever they wanted to women like me." Your courage in standing up to Brennan proved that justice is stronger than politics when judges refuse to be corrupted. I have thought about that sentence many times since she spoke it, because she said courage, and I want to be honest about what courage actually looked like in that case. It was not me recording a conversation in my chambers. It was a 22-year-old college student refusing a bribe, refusing to withdraw her complaint, refusing to be made smaller by a man with the full machinery of the DA's office available to use against her, month after month alone. That was the courage that made everything else possible. Sarah Martinez finished her degree, transferred to Brown University, attended law school, passed the Rhode Island bar exam, and became a prosecutor specializing in sexual assault cases. She told me over lunch after she passed the bar that Brennan's attempted cover-up had taught her the most important lesson of her life, that the system only works when good people refuse to let corruption win, and that she intended to spend her career making sure it worked. Her first major prosecution as an assistant DA was against a wealthy businessman who had been shielded by Brennan's protection for 2 years. She won a conviction and a 10-year sentence. Brennan served every day of his 8 years in a medium security federal prison in protective custody because other inmates understood exactly what a corrupt prosecutor represented. His law license was permanently revoked. His political career was gone. The man who had believed he was building a path to attorney general, maybe to governor, became a cautionary tale about what happens when you mistake the office you hold for the justice it exists to serve. My father said the prosecutor's job is to seek justice, not to seek office. Michael Brennan forgot that lesson and paid with everything: his career, his freedom, his reputation, and whatever legacy he had imagined for himself. He walked into my chambers one Tuesday morning and tried to give me orders. By the end of that week, the only thing that had been dismissed was him. I have been asked in the years since that case whether I was afraid when Brennan threatened me in my chambers, whether the threat of a well-funded electoral opponent gave me pause, whether I considered even for a moment that the path of least resistance might be the wiser choice for my own career. And I want to answer that honestly, because I think honesty is what this work demands and what the people who appear before this bench deserve from the person sitting in this chair. I was not afraid of Michael Brennan. I was afraid of the world his success would have created, a world in which Sarah Martinez's evidence sat in a buried file while Robert Sterling continued attending city council meetings and development dinners and the kind of political events where powerful men shake hands and decide together which rules apply to them and which do not. That was what frightened me, not a well-funded opponent in an election year. The slow, invisible corrosion of a system that is only as strong as the people inside it who refuse to let it be used as a personal instrument by those with enough money and connections to try. Providence, in the years since Brennan's conviction, has developed one of the highest conviction rates for sexual assault cases in New England. The victim advocacy program established by the new DA's office, staffed substantially by survivors who had lived through what the old system looked like, has transformed the relationship between prosecutors and the people they exist to serve. Victims come forward now without the fear that the person sitting across the desk from them is calculating whether their case is worth more or less than a campaign contribution. That is not a small thing. That is the entire thing. That is what the law is supposed to look like when it is working, not perfect, not without difficulty or failure, but oriented toward the right people, serving the right purpose, held in place by the insistence of enough individuals inside the system that it will not be bent into something else by those who find its principles inconvenient. My father said it plainly, and I have found it true in 22 years on this bench. The prosecutor's job is to seek justice, not to seek office. And when a prosecutor forgets that difference, it is the judge's job to remind them clearly and without apology that no one in this system, not the wealthiest defendant, not the most politically connected councilman, not the most ambitious district attorney, sits above the law that all of us are here to serve.